Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So today I'll be talking about the topic interwater disputes in India. So let's talk about the resources. So interwater state river water dispute. What are the main causes behind it? As we know, river doesn't follow any political limits. It has uneven distribution of water resources, increasing rainfall variability and frequent droughts, increasing demand of river water and polity, regionalization of the national polity. So, what are the major disputes and present status? So, first talk about we'll go to first talk about River Krishna. The dispute is in state of Maharashtra, Andhra Pradesh, and Karnataka. The date of constitution of tribunal 1969 and date of award 1976. Second river is Godavari, and the states under disputes are Maharashtra, Andhra Pradesh, Karnataka, Madhya Pradesh, and Odisha. Date of constitution of tribunal 1969 and date of award 1980. River Narmada, Rajasthan, Madhya Pradesh, Gujarat, Maharashtra. Date of constitution of tribunal 1969 and date of award 1979. River Krishna, Karnataka, Andhra Pradesh, and Maharashtra. Date of Constitutional Tribunal 2004, April 2004, and date of award report under Section 5, subclause 2 pending. So, what is the dispute settling mechanism? So, constitutional provisions. Entry 17 in the state list, water, irrigation and canal, water development and storage is a state subject, but qualified by entry 56 in the union list. Entry 56 in the union list. Regulation. It talks about the regulation and development of water under the control of the union is declared by Parliament by law to be expedient in public interest. Article 262 explicitly grants Parliament the right to legislate over the matter in entry 56 and also give a primacy over the Supreme Court. The ISRWD 1956, that is the Interstate River Water Dispute Act, includes provisions for the establishment of tribunals to adjudicate where direct negotiations have failed. Centre has been entitled with the power of establishment of tribunal and confirms the enforcement of adjudication of tribunal. There was one case, Tamil Nadu Kaveri Neera Pasna Villa Padugam Sangam versus Union of India. It was applied under Article 32 of the Constitution, seeking a direction to the Union of India to constitute a water dispute tribunal to resolve Kaveri water dispute. A direction to State of Karnataka not to proceed with construction of dams, projects and reservoirs across the river. Union of India and State of Karnataka opposed the petition and challenged the maintainability of the petition. Basic arguments of the respondents was that court's jurisdiction is based under Interstate Water Dispute Act, which is mentioned under Article 262. Second case was State of Tamil Nadu versus State of Karnataka 1991. Special leave petition filed by the Tamil Nadu against government, State of Tamil Nadu against the order of Kaveri Water Dispute Tribunal in the interim applications. Before the tribunal, State of Tamil Nadu filed 2 interim applications seeking interim relief. State of Karnataka was directed to not impound or utilize the water of Kaveri River beyond the agreed limit. An order was passed restraining the State of Karnataka from construction of dams, reservoirs, canals and new projects. Before the Supreme Court, the respondent argued that the court does not have any jurisdiction over this case. Supreme Court held that the tribunal is a statutory authority constituted under an act passed by Parliament and this court has jurisdiction to decide the parameters, scope, authority and jurisdiction of the tribunal. Court held that tribunal is having the power to issue interim relief orders. So let's talk about the judgment. The judgment was given that ordinance is to override the decision of tribunal. State legislation affect beyond its territory and it affect the right of other state. Supreme Court held that the tribunal have the power to issue interim relief. That power makes it clear that the order of the tribunal comes with the meaning of report under Section 5(2) and therefore said order is required to publish the official gazette as per Section 6 of ISWD Act. So what are the approaches of resolution? The whole river basin is divided into sub-basins and thereafter concerned parties are allocated with the command of sub-basin lying in their areas. Example, Indus Water Treaty 1960 between India and Pakistan. India has rights over three eastern rivers, Ravi, Beas and Satluj, and Pakistan over western rivers, Chenab, Jhelum and Indus. Similar approach was taken into Godavari river dispute among Maharashtra states Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Orissa. So what is principle of equitable apportionment? The proportionate share of states are decided on the basis of their respective properties, or area of drainage, investments, uses and total volume of water in the river. So what are the loopholes and solutions? First problem is property right issues. Solution to it is declaration of water as a national property. Second problem, plethora of factors. The solution is state governments allowed to be the only party. Third problem, delays in the decision making. The solution to it is setting up of time frame through laws. Fourth is enforcement. Solution is commissioning of an enforcement body. The last problem is political interference. Solution to it is experts and judges be a member rather than politicians. Some other solutions are creation of a quasi-independent hierarchy of institutions, like National Water Dispute Tribunal under it, dispute resolution, perceptive planning, information gathering, enforcement and maintenance, drainage basin oriented planning like Damodar Valley Project or Murray Water Commission Australia, defining priorities of water allocation. So these were the solutions to the water disputes in our country. Thank you.